Anti-SLAPP laws are procedural mechanisms in place in roughly more than half of the states in the U.S. SLAPP is an acronym. It stands for Strategic Lawsuit Against Public Participation. The intent behind anti-SLAPP laws is good. They're meant to protect free speech. They're meant to provide defendants sued over speech-related claims with a early opportunity in the litigation to have the judge take a close look at both the pleadings and the available evidence to determine whether the statements are even capable of a defamatory meaning or otherwise protected free speech. And if the defendant wins that application, motion, petition, whatever it's called in the particular state, then not only is the plaintiff's complaint dismissed, but also the plaintiff is made to pay the attorney's fees for the defendant. So in essence, it acts as a double slap to the face. There is debate, though, of course, over whether SLAPP laws in practice have the consequences that are intended. SLAPP laws at their core are intended to discourage, deter the rich man with deep pockets from chilling the free speech of someone that can't afford to defend a defamation case or other speech-related claim. We get calls not infrequently from potential clients who have a lot of money, and as we're explaining to them that the speech they want to sue over is not actionable, we may hear something like, well, the defendant doesn't have any money, so if you file suit, they're just going to delete whatever's out there, and we'll be able to bully him out of court. SLAPP laws come in to prevent those types of tactics because it can be painful to have to pay someone else's attorney's fees. However, at least in my practice of practicing online defamation law for 7 years, it seems that SLAPP laws have very little effect on the real deep-pocketed plaintiffs. Any number of billionaires or millionaires, they can afford to pay the anti-SLAPP penalty, so they'll continue to use the courts the same way that they would otherwise. Who it does deter, though, unfortunately, is the same people who we seek to protect by not imposing a loser-pay system across the legal landscape. For instance, the United Kingdom, in most circumstances, does have a loser-pay system, meaning you sue someone, and if you lose, you have to pay their attorney's fees. However, here in America, we consider that to be against public policy generally. Why is it against public policy? Because it closes the courthouse doors to poor people or just anyone who can't afford to pay that kind of penalty, who can't afford to lose. In most circumstances, the American rule is each side pays their own attorney's fees. There are exceptions for civil rights violations. There are statutory laws that may provide exceptions, discrimination laws. There's contractual provisions that can have fee shifting mechanisms in there should a breach occur. But generally speaking, across American jurisprudence, the general rule is each side pays their own fees. And I think that's very well grounded in reason. And anti-SLAPP laws certainly run afoul of that principle. And lawmakers should definitely be very cautious. I would only encourage the General Assembly, if anyone were to ask me, to consider what type of speech and really restrict the type of speech that anti-SLAPP laws apply to. Certainly, those very traditional notions of free speech, political discourse, whatnot, those should be covered by anti-SLAPP laws. Any speech that's traditionally covered by a privilege. But just someone's social media post or anything like that, it can create a system where while you're trying to prevent suits that chill free speech, you're also chilling or precluding the ability of everyday Americans to protect their reputation. There are plenty more arguments against anti-SLAPP laws. There are probably even more in favor of them. My only concern, again, is that they don't quite have the consequences that they're intended to have. They don't deter the people they're intended to deter. We already have mechanisms built within the litigation procedure, such as Rule 11, or here in Ohio we have revised code section 2323.51. Both of those will provide penalties for frivolous filings, for any lawsuit that is not grounded in fact or law, and those penalties can be applied evenly to both the litigants and the attorneys. And I think that a good argument can be made that the deterring effect already comes through those types of laws, especially in speech-related claims where judges are not shy to take a very early and very close look at the case to ensure that it isn't free speech, to ensure that it is capable of a defamatory meaning. That's across the board, and whether you're in a state with anti-SLAPP laws or without anti-SLAPP laws. There are better ways, in my opinion, to deal with it than to pass a just very broad and wide-ranging anti-SLAPP law that's, again, essentially going to close the courthouse doors to average Joes and Janes that want to seek redress for reputational injury or other speech-related harm.